Okay, now we are on page 2 of Trust Basics. I'm going to, I think, not continue to read the footnotes as I started off doing, because I want to just deliver the handbook in its pure form, and then I'll go back at the end and I will read the footnotes. Not sure how those will go together, but we'll just wing it and see how it comes out. Probably exactly what I said, just read the book straight through, and then on the second reading, I will just go through the footnotes for your reference if you're listening to this, just the audio or watching the video, and instead of watching the video and want to refer back to, just at least get it in your mind. I'm an auditory learner, so I like to hear things and then later go back and read it and look it up, and I highly recommend everyone do your research, and part of doing your research is checking the footnotes and the sources. Okay, so let's continue with trust basics. First, it must be understood that any trust, regardless of the many designations applied to them, is, in its most basic sense, a property interest held by one person, the trustee, at the request of another, the settlor, for the benefit of a third party, the beneficiary. And there's a footnote 4 there, but I'm going to keep going. The classification applied to a trust is based primarily upon its mode of creation, in which it may be created either by act of a party or by operation of the law. In the case of the former, trusts are divided into 2 types, express or implied. Without getting into the various subclasses of express and implied trusts, the basic difference between one created by express act of a party and one created by implied act of a party is that the former is stated fully in language, oral or written, while the latter is inferred solely from the conduct of the parties. These are very generalized definitions, so presented for want of space, since there are many intricacies concerning the true meaning of the term implied. It has been shown that, in a sense, the classification of express trust can only be applied based on what is implied by the language of the instrument which created the trust. And there's footnote 5 there. So we won't get into that. Our focus is on a particular written express trust type. And even though the above definition is essentially accurate, it does little to define the express trust as it is known in its fullest sense under the protections of the common law. Now, before I start the next section, I'm going to talk about this diagram here. It says creating a trust, and it basically just, in pictorial visual form, shows basically what they just said. So there's 2 ways to create this type of trust. It can either be implied, where that's not written, or it's not, it's not expressly communicated, or it's just implied based on acts, different acts that may happen. And there's more to dig into there, which we're not going to get into in this, as they mentioned, but that's one way to do it, or for a trust to be created. And that is something to put in the back of your mind. Okay. And then there are express trusts, which is what we're getting into now. And there's oral, which we're not going to get into. And then there's written, which we are going to get into. Okay, so again, this is showing how to categorize these different types of trusts. It is created by act of the law. And there are trusts that are resulting from the law, which would be, I'm not going to get into that because it's another rabbit hole, or constructive. So you have resulting trusts and constructive trusts. Okay, so we will back into the text. Because we are focusing on just this express written private express trust. So just keep that in mind, but there are other types. Okay, express trusts under the common law. The most adequate definition of the express trust is to be understood from the earlier case law, which has been eloquently summed up and restated in a clear, concise definition by Alfred D. Chandler, Esquire, footnote 6, in a report submitted to the Tax Commissioners of Massachusetts on unincorporated associations, footnote 7. His study was conducted as part of a legislative investigation into their economic effect on the state in 1911. In the first part of the report, at pages 6 to 7, he offers the following definition. Express trusts put the legal estate entirely in one or more persons, while others have a beneficial interest in and out of same, but are neither partners nor agents. This simple, adequate, common law right, any person or group of persons sui juris, footnote 8, may exercise, the trustees issuing certificates of beneficial and capital interest divided into shares, as well as issuing bonds and other obligations as freely as they open a bank account, have a passbook, and draw and circulate checks, or make whatever contractual relations are allowed to persons as a natural right. Again, referring back to sui juris. Trusts are sui juris. So that means that they are allowed to do what any natural person would have a natural right to do. And in brackets here we have italics, emphasis supplied in original, bold emphasis, and brackets information added to this particular edition. What becomes clear from this definition is that the express trust is not merely a property interest held by one for the benefit of another, like any basic trust. Rather, it is a trust created by private contract for the holding of a divisible property interest, wherein the trustee is empowered by the settlor to do for a beneficiary of his, the trustee's, choosing, whatever he may do for himself as an individual sui juris. Footnote 9. What has been created here is a trust organization, lawfully by natural right. As a general proposition, it may be asserted that one who creates a trust may mold it into whatever form he pleases, and that whatever one may lawfully do himself, he may authorize another to do for him. Footnote 10. Doing so requires no benefit, privilege, or franchise from any government or other outside party. Footnote 11. And therefore the parties owe no duty to any government or other outside party to the extent that no common law criminal or civil wrong is the purpose of the contract. Footnote 12. When done properly, the trust is afforded all the common law protections ordinarily given to private contracts, particularly the obligation of them. And that's in italics, as you can see. So just a side note here, I would recommend anyone watching the video as I go through this book, if you see a word that's italicized, or if there's any word that you don't understand, stop the recording and get out your law dictionary, Black's Law, or Bouvier's or Anderson's, or any of these great law dictionaries, and look up what that word means until you understand it. So let's go back for a second. When done properly, the trust is afforded all the common law protections ordinarily given to private contracts, particularly the obligation of them. And that's footnote 13. Now, the question is whether the parties to the contract are truly acting sui juris, i.e., of their pure, unadulterated common law, natural rights. Because if the parties import or associate benefits which grant an outside party a vested interest in the proposed contract, then the contract has acquired a third-party overseer intervener. Footnote 14. Okay, let's keep going. Declaration of the express trust. The declaration of trust is the trust instrument that constitutes the trust. It has been noted in trust law that no technical expressions are required to create a valid declaration, so long as the words used make clear the settler's intent to create the trust or confer a benefit of some sort that would be best carried out in the form of a trust. Footnote 16. A trust instrument doesn't necessarily need to be a declaration either, for a trust may be, and often is, formed out of the simple agreement or even a will. Footnote 17. But with an express trust, the declaration has been preferred since the beginnings of trusts under the common law of England, which otherwise shunned fictions of law. This is where careful attention to detail is most crucial, because in order to properly construe the intent of the settler, the objects, property, and manner in which all is to be carried out must be set forth in unambiguous, precise language so as to particularly create the express trust. And where the intent of the settler is unclear, under equity, interpretation is required to construe the intent of the parties, and the trust may be deemed invalid depending on the degree of ambiguity. However, when all is done properly, obviously, there can be no lawful impairment of the obligations of contract. Moreover, the declaration, by its terms and provisions, serves to establish the entire contractual arrangement, including the identities and positions of the parties, the trust name, jurisdiction, and situs, and all particulars of administration, all of which the courts of equity will fully support by the principle that equity compels performance. Footnote 20. The ultimate result is the creation of a bona fide legal entity, footnote 21, with its own separate and distinct juridical personality, footnote 22, with standing to sue and be sued, footnote 23, and to function as a person in commerce by and through its trustees. The term natural person has been applied to express trust by courts of equity because of its administration being carried out by men acting as natural persons. Footnote 24. Under this application, the trust's right of contract is alienable, whereas its creator's natural right of contract obviously is not. Footnote 25. The express trust nevertheless possesses, inter alia, the right to all enjoyments stemming from the contracts into which it enters, as well as the obligations imposed under such contracts. The express trust possesses the ability to hold, own property, engage in business transactions, and incur liabilities, including tax liabilities, as well as assume creditorship, including secured party status, like any other legal person. The trust corpus. The corpus is the body of the trust, i.e., the property being held in trust for the beneficiary or beneficiaries, the very subject matter of the declaration. It should be noted that virtually anything may be held in trust. Footnote 26. Anything, footnote 26, may be held in trust. However, there are certain things which, given their innate traits recognized in law, make for better subject matter, so to speak. Initially, the legal minds who perfected the express trust in America did so to accommodate for the great obstacles in procuring special charters for corporations intended to deal in real estate, which trusts eventually came to be known as the Massachusetts Land Trusts. It was when these individuals came to realize the immense benefits of employing the trusts for the purpose of holding land that they eventually expanded their utility to include the holding of personal property. These eventually came to be known as the Massachusetts Electric Companies. As an aside, when considering the presently hostile official attitude toward non-statutory trusts, what is interesting to note is that much of the express trust perfection is attributed to the Attorney General and later United States Secretary of State, Richard Olney, footnote 27. But the fact that the express trusts were initially primarily utilized for purposes of holding and handling real estate is very significant, especially in our present situation. The significance derives in pertinent part from the integral relationship between the law and the land. It is a fundamental principle of law that the land and the law go hand in hand. And in America, without the 14th Amendment, the law of the land is the Constitution with its common law principles and its substance of gold and silver. Footnote 28. Referred to in this sense, precious metals are regarded in law as portable land. The basic principle of law holds that land includes everything of value extracted from it, and without getting too deep into the operation of common law, it is this principle regarding the relationship of land and law which, by its operation, threw up an obstacle to corporate real estate ownership. In order to charter a statutory civil law entity to handle the substance of the common law land, special, if not extraordinary, legal circumstances must exist. These circumstances did not exist prior to the post-Erie federal common land, footnote 29, whose imposition was made possible by the loss of the gold standard substance of the law in 1933, footnote 30. A statutory entity is inherently accountable to courts of civil, which is legislative, jurisdiction, deriving subject matter jurisdiction from the corporate charter, over which the legislature holds in rem jurisdiction, as well by way of possession of the charter documents themselves. Whereas an express trust is obviously inherently accountable to courts of common law and equity, footnote 31, deriving subject matter jurisdiction from the trust instrument and corpus. As logic follows, in rem jurisdiction remains with the trustee at all times unless the trust instrument and corpus are surrendered to a third party voluntarily. In rem jurisdiction, i.e. actual possession, is key. This brings us to today. In the jurisdiction of the 14th Amendment, United States Public Trust, precious metal, the substance of the common law, is legally merely a commodity. Back in the Republic, however, it remains the staple for payment of debts, footnote 32. Though surface gold and silver are in considerably lesser quality and without a fixed standard upon which to be traded. The express trust under the common law, holding real estate, silver, or gold, is holding the very substance of the law under which it was created, thus ensuring that the bond between law and land and the powers and guarantees that come with it. Footnote 33. And I'm going to stop there, and I will come back and read certificates in the next recording.